The history of pattern drawings might not seem like the most exciting topic, but as with anything, the more I found out about them, the more interesting they became. This is a brief overview of the history of pattern drawings. Pattern drawings are not considered pieces of finished fine art, but they use many of the same techniques. All of the skills and techniques that artists use to describe objects, to show light, to show form, to show texture, are easy to understand when looking at fine art because we're accustomed to doing that. We can see how artists are using cross-hatching and thin lines and thick lines, areas of shade and tone, where the lines become sketchy and quick versus focused and intentional, are things we understand. And we're even familiar with certain kinds of what we call working drawings, like fashion illustrations, where they tip into doing some fine art, but they're also communicating technical information. Pattern drawings really exist using many of those same techniques, but in a category all of their own. These are drawings as information, as visual data. There are many other types of what I call worker bee drawings that are meant to achieve something technical. An axonometric drawing is one where the lines don't converge. They stay parallel. There are three different kinds: trimetric, dimetric, isometric. Mostly people use isometric, which means equal measure. All the axes are evenly spaced, so there's 120 degrees between each of the three directions of line. The advantage to this is that it's measurable. You can put a ruler up to the drawing and measure in any direction, and those measurements will be accurate. So these are well used for technical drawings that need to be measured. But they're sort of inscrutable to people who aren't well versed in how to read them because they don't replicate the way our eyes see things. Architects like axonometric drawings because they're measurable, but also because they're very easy mathematically to connect to the other most used worker bee drawing, which is the plan when you see something from above, and the elevation when you see it from front on. So that trio of different drawings works really well together to describe objects that need to be built. And most people can read elevations. It looks like a house, but struggle with the plan because it looks like a maze. So our brains shift into some other, what would it be like to live in there, or how would I go up and down those stairs kind of thinking, and we start having an experience instead of reacting to an arrangement or an organization. They're very powerful drawings as tools, but they're not realistic looking. And as with any technical drawing, when done well, they transcend worker bee drawing and turn into artistic statements. This is Herbert Bayer's isometric drawing for Walter Gropius's study at the Bauhaus in 1923, and all of the architecture and objects are recognizable as they were built, but this as a drawing turns into something that I think totally transcends mere communication. At the same time, the ambiguity that's possible in an isometric drawing can make them impossible for us to read. That has been used to great effect by people like M.C. Escher because they take advantage of the ambiguity and make something called an impossible drawing, where our brain can imagine something going away from us or coming towards us because there's no difference in the way that would be drawn. The drawing technique that best matches how our eyes see uses projections that employ perspective and involve vanishing points. As a result, these are the easiest types of drawings for the untrained, uninitiated to understand because they most closely represent just how we see things. There's another kind of drawing that's rarely discussed called a shop drawing, which doesn't care what the thing looks like, it cares how you make it. So it talks about the angles involved, where to do an operation, where to drill a hole, and what the drill bit used should be. So it's not a drawing of the hole the drill bit leaves, it's a piece of information that tells you how to create the object, regardless of what it ends up looking like. These don't do well in the outside world. They're really only used in shops to communicate between people who have learned this language. Pattern drawings developed over time to become the most refined method of using drawings, using lines, lights and darks, layout, to show information in an intensely precise way, because this is a legal document that must be accurate. Pattern drawings are highly codified. There is an anatomy of pattern drawings. And until very recently, the tools we used to produce them were totally old school. These are the tools that produce rule lines, even lines, and everyone had to master them. I find it very satisfying to see that even the tools manufactured to create pattern drawings were patented and have pattern drawings of the tools. A pattern drawing will have every necessary view required to understand the object, all fit on one page with no overlapping. And it's important to get all the information expressed visually on this one page. So here you see an example of a book of matches where we have one view that shows all the parts and the assembly open up. We have another view that shows just the inside component. We have another view that shows how the cover tucks into the flap, a side view that shows that there's actually 2 layers of those matches used, 3/4 view that shows how the folding structure becomes 3-dimensional, and one more view that shows how the staple closes it. So all the information we need to understand how that book of matches is made is evident in this one page of drawings. A patent drawing doesn't show the object, it shows the idea or the technology being patented. What is the innovation? So when you look at a patent drawing, you can tease out how the drawing is conveying that most clearly, so there's no ambiguity and no room for patent violation. It's not accidental that these patent drawings worked. There's a science to this art. It's a highly codified system that's executed by draftsmen who are trained to succeed, to create drawings that work. The drawing on the left includes a series of decisions about how to show form that end up confusing the actual object in ways that make it a flimsy legal document. The drawing on the right, although more difficult to read, is more accurate and produces a better legal document. Here are some of the components of producing patent drawings. Different effects can be achieved not as individual style. It's not like I draw a tree this way, so here's my tree. This is part of a language or a system. Remember that black ink is binary. It's on the page or it's not on the page. There's no gradients involved here. So if you need anything that is a tone, you have to use stippling, small dots of ink. If you have something where there's a transparent surface over something else, you'd use straight lines to indicate that. Straight lines are used to show curvature or reflectivity. And there are conventions in where you would use straight or broken lines. Some of these have become regulated, some are merely agreed upon, but different kinds of lines mean different things. If something is visible on the surface of the object, it gets a straight line. If it's inside the object or beneath the surface, it gets a broken line. So the line quality helps us understand the object. Also, if something needs to be included in the drawing for us to understand the object, but isn't part of what's being patented, it's drawn with dashed lines. So the roll paper cutter in the lower right is shown in solid lines because that's what the patent is for, and the roll of paper is shown with broken lines because we just need to understand where it goes, but it's not part of this legal document. Lines are also used in ways that tell us what the material is. Transparent material is shown with these diagonal lines that clearly aren't part of a perfume bottle or pencil organizer, but help us understand that it's glass or acrylic. These conventions extend to the types of views and ways of dealing with explaining what something looks like and how it works. So when you've cut through something and created a cross-section, how you apply the lines can help you understand if the object is going away from you or towards you, if it's concave or convex. Also, if something is too long for the page and nothing interesting is happening in the middle, if it's all the same, if it's one single extrusion, you can break the view and indicate with a bracket that more stuff goes on in between, but we don't need to know about it. So all of that information is language, but it's described with lines. My favorite type of view is the exploded view. You can show so much all at once. On the left is the object all stacked together, and on the right is the exploded view where you see the separate components that make up the center stack of this toy, and the bracket on the right indicates that even though it's exploded, this is all counting as one thing. If an object is too long to fit on the page, it can be rotated, but then all the other drawings on the page must also be rotated. So here's a boat that was too long to fit on the page. It gets turned up, and so do the cross-sectional views. I included this image just because it's also interesting to note that Abraham Lincoln is our only United States president to have ever filed a patent. There's no more to that story. I just thought it was worth showing you. As a result of this really developed visual language, there's an amazing complexity of idea and innovation that can fit on one small page. I showed this patent earlier, but I want to revisit it because it's an astounding document. At first, it just seems like a forest of numbers and hatched lines, and it says it's a spray nozzle, so I guess it does something, but I can't tease it out beyond that. Looking more closely at it explains some of its mysteries. Figure 1 on the upper left is a section through the nozzle. It's been sliced down the middle. The directional lines and the pattern used, the balance between the straight and dotted lines, show you the different parts that are made separately and then assembled. So that was pretty easy to figure out. Figure 2 is a plan view looking down at the object, and you see on its edges, right and left, some dotted lines and the number 1 and arrows. That indicates where the section of figure 1 was taken. So you can see where this object was cut in half and which direction you're looking at it to get figure 1, shown on figure 2. I was really confused by figures 4, 5, and 6 because it's hard to figure out what those are floating over there. Then I realized that those dotted lines match the ones in figure 1, and what we're seeing there are the 3 separate parts pulled apart, so we can understand each of them as a separate object. Because ultimately, this is a sprayer nozzle, and the way it works is the combination of shapes that separate the water flow and spray it outward. So our ability to understand what those shapes are in this pattern drawing is really important. Also on figure 2, you can see the number 7. That's a separate section line, and down below the image where I've cropped it, you can see that section. So just on figure 2 alone, we're seeing where section number 1 was taken, where section number 7 was taken, and a lot of other information collapsed into one small drawing. Pattern drawings can even communicate more than just the reality of what something looks like by suggesting how it works without overwhelming the other necessary information. These are 2 patterns that show the object, but more than that, they show the behavior the object allows. On the left is a dishwasher, patented because it had a new way of spraying water. So finding a way to use arrowed lines to show spray direction was an important part of that information. And the patent on the right is for a very familiar object. You squeeze it and the eyes and ears bulge out. Without seeing that action involved, the patent isn't especially useful. So we see a hand gripping and squeezing at the bottom. Although now patent drawings are an understandable language, it took a long time to arrive at that because some of the decisions had to come out of lawsuits and misinterpretation and problems. The history of patent drawings is a really rich and interesting study of different types of drawings and the evolution involved in getting them where they are today. Patents always have writing, and they almost always have drawings. The very earliest only had models, because at the time patents were for technical innovation, so having a model would best demonstrate that technical innovation. When the patent office began to tremble under the weight of all of the patent models they had collected, they realized that some patents could just have a drawing and that would save space and energy. But that combination of drawing and written language is an important thing to understand because the drawing can't possibly show you all the information, but the language also can't describe something in a way that is understandable and irrefutable. The combination of the two is where the magic happens. The whole reason we have patents is to guarantee progress as a society, as a culture, but mostly as a nation. When you publish your innovation for everyone to learn from and use, the government will help you monetize your ideas and retain ownership of them. That's the foundational logic behind patent systems around the world. Patents are very old. They date all the way back to medieval times. Patent protection is mentioned in the US Constitution. But patents at the beginning of our nation's existence happen on a state-by-state basis, not nationwide, until the Patent Act of 1790. At that point, there were no drawings, there were just models. The Patent Act of 1836 required information on newly granted patents to be made publicly accessible at libraries throughout the country, because we realized that this system of sharing information was flawed if there wasn't a formalized way to share it. And that began to shift the focus from writing and models to clear drawings, something that could be shared in multiple copies at greater distances. One great example of how valuable innovation was as a national resource is that during the War of 1814, the US patents were loaded into boxes and hidden from the British. This was a major archive of our nation's ingenuity and innovation. All great American innovation lives in our patent archive, and protecting it was a problem, and in today's news we're realizing is still a problem. By 1845, there were 502 patents in the United States, and by 1859, there were over 4,000 patents. So this was quickly adopted as a good way not only to share information, but to try and monetize your innovation and protect it. On December 15th, 1836, a fire destroyed everything. Every paper, every book, and almost all the models for the 46 years of patents, which was almost 10,000 patents. After the fire, 3,000 models and drawings were recreated. The government hired people to rebuild and redraw those patents. And from this point on, the patents were numbered. Before that, they were just filed under inventor name and date. So all the recreated patents that were rebuilt or reconstituted after that 1836 fire had the letter X added to their number. So any X letter patent is one that was recreated from lost documents. The government collected and copied any patents they could find from inventors, from other governmental offices, to reconstruct the patent collection. And this led to all sorts of problems. The restored patent for Whitney's cotton gin has ghost images on the side that were once darker. You can see them better in the reproduced version on the right, that showed saw blades chopping up the cotton fibers, as all cotton gins did by the mid-1830s. But Eli Whitney's original patent didn't use saw blades, it used wire teeth that rotated on a drum and combed the cotton fibers. So this is a really famous document on the left, Eli Whitney's cotton gin. It's shown all the time as an example of early American innovation, and it's sort of fraudulent because by the time they were redrawing it, people had just sort of forgotten how the original one worked and drew a cotton gin from the 1830s instead. A whole industry grew around the process of creating and filing and maintaining and defending patents. You may have noticed in the corner of each of these slides I've been showing the name Munn and Company on the colored patent drawings. Orson Munn and Alfred Beach were America's most successful patent attorneys. By 1860, 1/3 of all patents issued by the U.S. Patent Office were passing through Munn and Company's offices. They were developing a sort of monopoly on this whole industry. In 1865 alone, they filed 3,500 patents. By 1924, their name was on more than 200,000 patents, more than 1/7 of all the patents ever issued by the government at that time. In addition to being patent attorneys, they took over publishing a small trade journal in 1846 called Scientific American. They specialized in publishing information about innovation, using patent drawings as illustrations, and they published a weekly list of all patents issued by the Patent Office. This was the fastest patents had ever become available to the public, because this private publication was stepping in to spread the information faster than the government was able to. Because of this, they became the go-to folks for information and questions about patents, and they set up a whole subdivision called Scientific American Patent Agency. Yes, the journal of that effort was the Scientific American publication that's still in print today, which is pretty remarkable that the trajectory of this publication started with looking at a way to spread innovation and share patents and turned into a larger broadcast system for ideas. Before 1870, there were no rules about drawings. They could be any size, in any medium, they could be in black and white, they could be in color, didn't matter. In 1871, there was a new patent act that added new requirements to try and standardize patents. From that point on, they had to be black and white drawings of a specific size, so they could all be filed the same way, recorded the same way, live in the same size file cabinets. The Patent Office then hired the Graphic Company of New York to redraw all the patents from 1790 up to 1870 to conform. So the good news is we have a patent archive where everything is neatly the same. The bad news is not only did we lose a lot of those early patent drawings, which were exquisitely beautiful, but we lost the ability to make patent drawings that were also, in some weird way, artistic statements. The patents at that time got crazy regulated, and the drawings were way more patent drawing language based. They're just as beautiful, but they're their own thing. They're not familiar as art or drawings. They're not using techniques from fine art. It's a whole new language that was developed specifically to make the playing field more level, to make these understandable in a more legal and regular way. Copies of patents were obtainable from the U.S. Patent Office for just 10 cents. You could send coin or money order in the mail and get back a copy of a patent. They also issued a weekly gazette containing abstracts of all the patents that had been issued that week. And these gazettes were sent to public libraries around the country. So even the sharing of patent information was now formalized and democratized and turned into a regular system. So here are the new rules from 1871. Reproduction is the motivator. Because things are now designed to be reproduced in the Gazette, the drawings had to be reconfigured to survive that printing process. All of these decisions about line weight and line quality were based on this basic premise that the original drawing was one size, the published patent drawing was reduced, and the printed Gazette was even smaller, and the quality of lines needed to survive that scaling down. So the line weight and the spacing are really important in patent drawings after the 1870s. Artists needed to use pure white stiff Bristol drawing paper of 2 or 3 ply thickness. The drawing page had to be 11 by 15 inches with a 1-inch margin, so the drawing had to be 8 by 13 inches maximum. Could not bust past those margins. Nothing could be less than 1¼ inches from the top, so there was room for the header information. And art stores started selling what were called patent office sheets that had the inventor and attorney titles printed in the lower right-hand corner, which I find hilarious because if you were able to produce a patent drawing in all of its complexity, you probably also could write the word inventor in the corner. Patent drawings had to use only black waterproof ink, and the language of the Patent Act said no color must be used for any purpose upon the copy of the drawings. From 1871 on, photolithography was used to reproduce patent drawings. The clarity of the lines and the distinctness of the lines not overlapping really mattered so that it would reproduce using that still relatively crude printing process. Remember, we did not have easy methods to copy drawings. Interestingly, our ability to reproduce drawings is also linked to patent drawing creation. A man named Chester Floyd Carlson was a patent attorney who wanted an easier way to copy patent drawings, not doing it by hand, not spending a fortune on technically trained artists to recreate drawings, and that led to his invention of xerography in 1938. That patent was transferred to the Haloid Corporation, which then became the Xerox Corporation. So all of our ability to make photocopies goes back to the frustrations involved in reproducing patent drawings. There are some other conventions that are, I think, exciting to look at. Outline shading creates something where the heavier object line is on the right or below the object, as if it were casting a tiny shadow. And the Patent Office wrote about the shading of convex and concave lines. Light comes from the upper left-hand corner at an angle of 45 degrees. You might not think this matters, but this image shows you the subtle difference in where those lines are put in how you would understand the object. You can understand if an area is pierced out of the form, is set into the form, or is sticking out from the form based on where that extra thickness is put. So with just that 2-line weight difference, a whole series of different shapes can be described that would otherwise look the same when drawn with 1 line weight. The style of the lettering is not regulated. The only thing the Patent Office cared about was their boldness and clarity. The lettering had to be 1/8 inch tall minimum, so that when it was reduced to the Gazette, it was 1/24 of an inch tall and still printable. As a result, you get a crazy variety of really fun lettering on patent drawings. All the lines needed to be clean and sharp and solid. The language of the Patent Act says freehand work avoided, no sketchy lines. Shade lines should be oblique parallel lines, which may be about 1/20 of an inch apart. Shading should be used only on convex and concave surfaces, where it should be used sparingly, and may even there be dispensed with if the drawing is otherwise well executed. So in other words, no shading is better than bad shading. Extra information is just going to confuse a drawing. Lines and ink should only be added when they're helping to clarify something. This image really nicely shows the same rectangle drawn 4 times, and each time is describing a very different thing. On the upper left, it could be almost anything. It's just a rectangle. Below that is a cross-section through something, and there's a wall thickness top and bottom with the diagonal lines showing the cut. On the upper right, the lines help us understand that it's a rounded surface coming towards us, and on the bottom, we then see that we've cut through a piece of tubing with a wall thickness, and the bottom is farther away from us. Lines on a flat surface are shade lines, and they're showing polished or shiny surfaces like glass, in which case we call them gloss lines and they're diagonal, or they're there to explain volume on something like a tray or a box that would be hard to read otherwise. The lightest shade lines fade out or break into smaller segments to help us understand that it's a passing thing, it's not a solid surface treatment. And this is also when the bracket to contain exploded views entered as a formal distinction. Reference characters are all of the letters and numbers on a patent drawing, and they're added by the attorney in pencil so that they match the legal document, and then they're inked by the draftsman so that they are legible and at the right size. And there are some rules about these numbers. They must not cross the lines of the drawing. They have to be inside the part or outside the part. They need to have the same reference characters used for a part throughout all the drawings, so part 192 has to be the same thing on all the drawings. They cannot be on a shaded surface. If that's unavoidable, they need to be in a little clearing, a little clear area in the shaded surface. And the reference characters are connected with something called a lead line that takes you to the part being referenced if they can't actually be on the part. And those lead lines are not supposed to have arrows. There were also standards imposed in the 1871 Patent Act for representing materials. Over time, those were expanded to include basic mechanical operations, standardized parts, and connections as well, as a way to save time in creating and interpreting these drawings. And you can see there are some pretty wonderful shorthands for a wood surface or concrete or a liquid. If that's an important part of the functioning of the object, it needs to be part of the patent drawing. When I was looking for some interesting older patents to include, I found this one for rolled toilet paper. And first I was amused to see that toilet paper used to have a wooden core, because of course we hadn't yet figured out the cardboard tube. But then I also appreciated this on the patent drawing because they've drawn it with the indicator for wood surface, so I understand that that's a wooden roll in the middle. These material lines are really useful in helping understand what's going on in some drawings, and they're especially useful in section views where there's a slice through to show the thicknesses, because each of the parts in this iron is made of a different material, and that's an important part of how it's made and assembled. And in one section drawing, we can see not only the wall thickness and the different parts and some of the technologies inside, but also the changes in material. As we aged into the era of electronics and circuitry, these standards continued to get expanded to help maintain an understandable shorthand and keep things from getting grossly overcomplicated. There are material standards, but there are also colored standards because patent drawings need to be black and white only, but oftentimes color is part of what needs to be discussed in a patent. And here's an example of how important that information can be in a black and white drawing. If your trademark or patent includes something where the coloring is important, you can communicate that. Just as an FYI, I couldn't find anywhere else to stick it in here. On September 24th of 1877, the brand new patent office, which was built to be fireproof, caught fire again, and nearly 80,000 models and 600,000 drawings were destroyed. Amazingly, no actual patent information was lost because at this point all of the publishing and duplication involved in the system of distributing through the gazettes and the libraries allowed them to very quickly rebuild that information. One patent does not all innovation fit. And as a result, neither does one type of patent drawing. There are three basic types of patents: utility, which is how something works; design, which is what that something might look like; and more recently, plant, how we grow something. In 1842, a statute was passed to allow patents for a design, rather than a technology or a mechanical innovation. And this came out of our newfound ability to print on fabrics, to print surfaces on things, to make busts or statues in repeat, to pattern objects, to make shapes or configurations or manufactured goods where the surface was important to the innovation. So essentially it came out of the Industrial Revolution and our ability to decorate manufactured objects. Amusingly, the very first design patent doesn't even have a drawing. It's just a language-based description. It's for a typeface, a patented typeface, so it is merely described with language. I was trying to find good evidence of early design patents to show you. The second one is on the right here, and it's unintelligible. It's been reproduced later photographically, making it very hard to understand what the patent is for, but it's for an image that would have been molded onto a metal ornament. With design patent drawings, we need to be way more descriptive about surface than we are with structures. So the drawing techniques changed for these drawings. Suddenly the stippling and the shading allow us to show texture and shadows, to show three-dimensionality, and we're doing more than we did with the utility drawing. On the left is one tool where in the section view from the utility drawing, we're using lines to show information: material, thickness, transition from one material to another, attachment points. The design patent for the exact same object on the bottom is all about the surface, which material is rubber, where there are bumps for grip, where there are air vents, and the quality of line is used differently in each of those drawings. It became pretty swiftly clear that design patents needed their own language. This is the same Electrolux vacuum cleaner in a utility patent and in a design patent, and yet they look completely different. The utility patent isn't concerned about scale. It's the whole vacuum is compressed into a smaller thing that just showed us the innovative motor. On the right, we need to show an accurate representation of the scale and the surfaces, so it's been turned vertically on the page to fit, and it's been rendered with different stippling and line techniques to show us surface. Two totally different languages of drawing. I have to show you this drawing rotated because it's so beautiful that seeing it sideways isn't fair. The pattern lines don't have a translation chart to be understood as materials. This drawing shows them. You understand where the shiny metal is, where the textured laminate is, where the fabric overlay is, all based on the way line and stippling is used. There are still a lot of conventions in design pattern drawings. The object is shown in broken lines, but the decoration being patented is shown in continuous lines. There's a real difference here. The patent is not for a chest of drawers. The patent is for the leaf decoration being applied to those drawers. As a result, we can apply that pattern to a number of different things because it's a patented pattern. The arrangement of the drawers and the height of the desk don't matter. Design patents are shorter term and they're awarded with much less scrutiny. They became an important tool for designers to get their work protected, and in many cases, they became the tool artists and designers used to get paid. They would file the patent and then transfer the patent to their client and receive a transfer fee instead of a design fee. But they also present problems. This patent seems technical, but it's really just based on what the chair looks like. And this is a wildly innovative chair technically. It's the first injection molded plastic chair. The legs were made separately and snapped on. The back uses the fins to introduce flexibility, but still leave all the pieces attached so that liquid plastic could flow through the mold. And yet the patent is a design patent. It just says, here's what my chair looks like. As cases of patent infringement went through the court system, manufacturers began to realize that design patents protected subjective information, the surface, the shape, which was easier to alter and difficult for a judge to really understand. So they began using combinations of patent types for better coverages. Eero Saarinen's womb chair has two patents. One says this is what the chair looks like. The other more interesting patent is the utility patent, which shows how a flat sheet is transformed to make the three-dimensional volume of the chair. So anyone using that transformation is violating the patent, whether their chair resembles the womb chair or not. It's interesting to start looking at the relationship between design and utility and how designers and manufacturers started hiding utility. Here's an example of a patent for a men's suit that is a utility patent based on the construction techniques that allow venting in the back, not a design patent that would just say, here's what my suit looks like. You start to have to wonder, is something utility or is it fashion? Is this a molded steel heel cup because it protects a whole range of ways of making shoes? Or is it a patent for a steel cup because that would produce a more fashionable shoe? And the answer would be yes to both. Oftentimes, design patents border on the ridiculous, and this is especially evident in toy design. These are two design patents for toys, and all they're protecting is what these objects look like. These patents merely say, the thing you sit on and bounce looks like this. The humanoid robot figure we're going to make looks like that. A utility patent, though, can protect and even hide all sorts of change and innovation, regardless of what your object looks like, over the longer life of that patent. So this is Mattel's patent for a talking doll. You pull the string and a small record player inside is activated, and the speaker in the chest plays some pre-recorded message. But on the right is the talking Barbie from 1968 that best took advantage of this. The utility patent and the talking Barbie don't share anything except the mechanism inside. They look completely different. And that might have been Mattel not wanting to explain that they were miniaturizing this innovation and sticking it in Barbie, or it might have been that they wanted to be able to put that in any number of other dolls because it's a patent on what the thing does, not what it looks like. A new kind of patent was introduced with the U.S. Plant Patent Act of 1930, which required new ideas about patent drawings. A plant patent is a little different. It allows one person, the patent holder, to grow the newly patented plant. The first plant patent was issued in 1931 for New Dawn, which was a climbing plant which bears champagne-colored roses and is characterized by its ever-blooming habit. What a tragedy that these images are now available only scanned or redrawn in black and white. I'm hoping I can find the original images because the seventh plant patent is for a peach, and I hope you agree that reducing a peach to a black and white photocopy is sort of a crime. Because plant patent drawings were allowed to be in color, and we see a bold return to the beauty of a colored patent image. A plant patent is granted to anyone who invents or discovers and then asexually reproduces any distinct and new variety of plant. And it was an important part of helping advance farming in America during the Depression when producing more food was clearly beneficial. Today's patent language for plant patents says Plant drawings are normally photographic, but may be presented in other mediums, such as permanent watercolor renderings, which faithfully present the appearance of the plant. Such drawings are not mechanical drawings and should be artistic and competent in their execution. Figure numbers and reference characters need not be used unless specifically required by the examiner. The drawing must disclose all of the distinctive characteristics of the plant which are capable of visual representation. So you can see they work much better in color. They don't say much more than the plant looks like this, but the actual patent is for how that is recreated outside of nature, or using nature but in a laboratory. The early color images are really beautiful. The plant patents from the 1940s go all out in their botanical glory. On March 9th of 1943, inventor M.B. Crane received a plant patent for his new thornless, long-bearing blackberry plant, which made harvesting the fruit a lot easier. So it may seem weird to extend patent drawings into the plant patent realm, but you can pretty quickly imagine, when you go to the supermarket, how much patented innovation is there. I hope you've been watching these thinking to yourself, I don't think patent drawings look like that anymore, do they? Because they don't. What happened to create a world where we produce such horrible patent drawings? We don't make nice drawings anymore, but there are a lot of valid reasons why we don't. Even way back in the old days, there were patentable things that went beyond function or mechanics and tipped into behavior. What we were patenting shifted as innovation shifted from new combinations of mechanisms to other things. We aged out of our era of mechanical progress, and our patent system sort of didn't. So when you patent the slinky, the patent is actually for the behavior of a thing that goes down steps, since the manufacturing of a spring pre-existed. The patent for the hula hoop also is about the behavior of the object. So these are not patents on objects, and they're not patents on materials, and they're not patents on shapes. They're patents on less tangible interactions that are just as much a part of the design. And as we age into a world that's way more focused on the innovation of interactions, we have to figure out how patent drawings can do something different for us. We're so focused on electronics and interface today that we're actually fooling ourselves into thinking the things don't even need consideration. The iPod patent is way more focused on the system of use than on the objects involved. There's this rectangle thing, but then there's pages and pages and pages of other drawings that show the system of where that rectangle thing fits into other electronics and how it enables different activities and behavior. How does a drawing show interaction? It's no longer about the quality of line. In fact, a nice drawing would be a problem because it suggests that things in the drawing matter, when in this case, the things in the drawing do not matter. It's just important for us to understand that when we hold the thing in our hand and twiddle it with our finger, the patentable stuff happens. So if you drew the hands well, you would be confusing this patent. Even though what patent drawings are hasn't changed, and what we're trying to use them for has changed, the basic idea that the patent drawing has to clearly show the information that's being protected legally is still the same. That's why our patent drawings have devolved to be ugly, because we're trying to go for clarity of idea and intent. In many ways, today's patent drawings are just as complex in what they're taking on as earlier patent drawings. But now instead of concentrating all the communication on one page with density and depth, it's being spread across lots and lots of one idea thin drawings. And that's because we're doing things digitally now. We don't have to worry about the cost and effort of reproduction. We don't have to scale things down with photolithography. We can have endless numbers of pages of drawings to communicate a complicated situation. Here's a very recent patent for Amazon's drone distribution system, and I love this patent because it reads like a video game. It's a whole sequence of what's going to happen when the drone arrives at the docking station in the cargo container on the train, and how it picks up the next order, and how it flies back out. The patent also shows that this is a train-based system that communicates to major distribution hubs. It shows the inside operating of the container. And it's also pointing out that this is a patent on a system, not an arrangement of hardware. That same container could be on a train, on a truck, on a boat, doesn't matter. It's how the drone and the container will interact to deliver goods. And this is clearly a product of the internet age when reproduction digitally is free. The clarity is now important to survive assault in the courts, not to communicate to others. And there's a different thing that patents are doing today. We're no longer interested in communicating our innovation to other people to help advance society. the clarity involved is important so that it survives the assault in courts, not to communicate to other people. We've also fractured utility patents into 4 types. There's method or process, machine, article of manufacture, and composition of matter. This is a chemical process from 1930 on the left and from 2011 on the right. The drawings have changed pretty dramatically in style and the way they're executed, but what they're doing is exactly the same. Do they even need drawings? Probably not. I bet we will eventually age out of this legacy. The drawings were produced because this type of patent arrived at a time when that was the system of communicating. Drawing plus language equals patent. We're aging into types of patents where the drawing is sort of a problem because it's defining the innovation in a way that runs counter to the innovation. But for now, we're sort of stuck with this system of drawing and text, and we're also stuck with computers, which make it possible for anyone to produce a patent drawing. You no longer need to hire a highly trained draftsman who knows how to use all of that equipment. You can just use some computer drawing system and arrive at a really hideous patent drawing that shows the basic idea of a necklace also working as reading glasses. When draftsmen were producing drawings, they understood the language and the tools and could produce a technically proficient, acceptable drawing, but they also were artists, and I would argue always worked to produce drawings that were inherently beautiful, beyond the merely technical. Now they're produced by people who have no particular interest in artistic integrity, and so we're only interested in the legal implications of the drawing. Doesn't matter what the rest of it says. We don't worry about protecting our national intelligence from war and fire anymore. We don't even think of our intellectual property as a national possession or a shared resource. We now work in a global economy, and what we get are corporations and people protecting their own personal innovation and their personal value. It's not a national commodity. It's really easy to make fun of these drawings. This is a patent for a filter over an intake vent in a whirlpool bath so that your hair doesn't get stuck. So the person and the hair are not part of the patent, and they're drawn so that there's no way we could possibly believe that they're part of this patent. But for whatever reason, we need to show how hair would interact with the filter. I could make fun of this drawing, but essentially it is functioning in a useful and accurate way. And in many ways, it's a document that speaks to the problems of our time. In 2001, we were really worried about getting our hair stuck in hot tub filters. In 1871, we were more worried about being buried alive. This is a patent for a life detector for coffins, so that if you accidentally buried alive, you could ring a bell and people could dig you back up. That wasn't a joke at the time. This was the result of some medical conditions that were leading to that as a problem. Patents also are turning into a really wonderful way to look backwards and interpret who we were at the time we created them. But again, what patents are used for has really changed over time. They've gone from a contractual agreement to share ideas and guarantee fair monetization to something that keeps ideas hidden and secret while securing a tool to monopolize an invention and prevent others from using it. Or even with all the crazy patent trolling we have going on today, where people patent ideas they will never actualize just so they can sue others later, who will inevitably tread on patents. We're getting patents so open-ended that they can't really be for anything except a legal experiment. Even this behavior is not unique to our times, it's just more severe now. On the left is a patent from 1891 for a small piece of wood. It's a patent drawing right out of a Dada Marcel Duchamp experiment. It's a toothpick patent. On the right is a patent for the iPad. The patent is a design patent, and you can read this drawing. It has solid line around the outside. Every other line is a dotted line. And in the language of design patents, that means the patent is only for the outside rectangle with the radiused corners. All the other information is just showing you that it's a shiny surface, and there might be a round button somewhere. Look how many people's names are on that patent. This is Apple hedging their future by saying, we want all of our devices to have a radiused corner. We're going to see if we can get a patent filed for a rectangle with rounded corners. And if we can, that means no one else can make something in this shape, and it's our identity. Unfair, wrong, bad, but not new. In some crazy way, patent drawings still have a way of functioning as astounding visual statements. We might not draw them with the same care or skill, but we're still the same weird, innovative people with the same need to tell everyone what we're doing and the same desire to make sure no one copies us. These are patent drawings for artificial plants for aquariums, and in a weird way, they start to be Ernest Haeckel nature studies. I have no idea why anybody sat through that or if you found it useful, but In preparing some information on pattern drawings, I sort of fell in love with at once their simplicity and their complexity, how they force us to quantify our innovative spirit, and how they also then provide a landscape for progress and innovation that is sort of exciting. They also end up being documents unlike all other drawings, and they're not something I think a lot of people spend time looking at, and I thought maybe getting this out there would help inspire some people to care more about them.